Well, hopefully I'm doing this right, and if not, I am sure we'll do some changes in post. Let's see. Okay, so hopefully this is working, and I'm going to try to do some broadcasting at the same time. So hold on one second while I get this set up, because I'm doing this all last second because this all came out. All right, also, I am doing this hopefully on YouTube, and I hope I'm doing it correctly. So, again, apologies for me figuring this out as we talk through it, because, again, I was expecting to do this in a couple weeks towards the end of the semester, but or end of the term of the Supreme Court. But so hopefully all this makes sense. I'm doing this both on Twitter and on YouTube at the Pros and Con Law channel. In a few weeks, hopefully, I'll have a new channel that's called Keep Left, which is going to be set up for more lefty liberal discussions of things like that. So welcome on Twitter, welcome on YouTube to whoever's around, and let's see. As we go through this, we'll be looking at things like the opinion that was leaked today. We'll talk a little bit about that, as well as issues involving the leak itself, as well as what's the content of this leak in Dobbs versus Jackson Williams Women's Health Organization. For those who don't know, the case involves a challenge to the Mississippi law, which outlawed abortions after about 15 weeks. This has been the opinion that a lot of people have focused on as possibly overturning Roe versus Wade, as possibly, you can tell how unready I was since my hat is all completely all over the place. Anyway, looking at the question of what would happen. Now, tonight, apparently, the draft majority opinion was leaked. This is labeled first draft at the top. It's by Justice Alito, who has been one of the justices, probably along with Thomas, who ever since he's been on the court, has been taking a very negative eye on Roe versus Wade and wants to push it and wants to overturn it one way or another. This has been tempered somewhat by Kennedy and to a very lesser extent Roberts, who and over the last 20 years there's been different sort of opinions going one way or another on different kinds of laws involving different abortion challenges and so forth. What we have here is, and I've just done a brief look at it, is this opinion by Justice Alito in which he goes through and, for lack of a better phrase, overturns Roe versus Wade. Now, we have to go through a couple caveats here, many caveats. This is a leaked first draft. First drafts are usually written by a law clerk for the justice in question. It doesn't necessarily mean that that's going to be the final decision. It could very well be. We don't know the vote. If we suspect, according to the rumors, there's been a report out by NBC News that, in fact, one of the things that's happened is that Chief Justice Roberts would have kept Roe versus Wade, but would have upheld the Mississippi law that in question, which means he's probably a dissenting and concurring opinion, which would leave him and the three most likely liberal justices. The three justices are almost certainly Breyer, Sotomayor, and Kagan voting to uphold Roe versus Wade, which leaves five other justices. What we can discern from this, if this is in fact correct, is that probably Justice Thomas appointed Justice Alito, since Justice Thomas would be the most senior justice in the majority, probably would have appointed Alito to write this opinion. here's the caveats. This is a first draft. This might have changed since then. It's fairly strident, but maybe first drafts for Justice Alito are strident, and maybe he tempers them ultimately. For people who have read his opinions in the past, this does feel like a Justice Alito opinion. And we'll get into hopefully some of that as we go through here. In terms of the vote, there are 5 justices here on that side, perhaps. We don't know if there are any concurring opinions. Concurring opinions can temper a majority opinion. Alito may, in fact, deliver the opinion of the court, but any one of the other 5 justices may say, look, I agree in some respects with the opinion. Like, I agree that the law should be upheld, but I don't agree in overturning Roe versus Wade. And so we may wind up in a situation in which Roe versus Wade is actually not overturned, but maybe limited in some way, shape, or form. So those are the caveats that we have to go in with this. The suggestion is that this is a majority opinion, that the opinion itself will encapsulate what will be the law going forward. So let's work on that assumption, even though it may not be the case, but it seems very likely if this was leaked and if the reporting that Politico is given is correct. And I will bring up the case right now and sort of walk through it a little bit with you. So this does seem to be very much on a standard Supreme Court of the United States case format. You have everything does seem to be in order according to how opinions are usually presented. And so from that angle, it does look very much like that kind of setup. You have some sort of topical language at the beginning. Abortion presents a profound moral issue on which Americans hold sharply conflicting views, blah, blah, blah. Then he sort of goes through the history that culminated in Roe versus Wade. Roe versus Wade in 1973 ruled that there was that abortion after or before the first 2 trimesters of woman's pregnancy could not be outlawed by the state. And in fact, it's sort of a balancing test between the rights of the unborn child and the rights of a mother who is being pregnant to decide with her doctor whether or not to have an abortion. Roe versus Wade has been criticized in many quarters for the quality of its writing, the fact that it does seem to base its opinion on the medical facts of the day, the medical practices of the day, as opposed to a concrete constitutional framework. Be that as it may, it was a balancing test. It was not a hard case. It was 7-2 at the time, and it was considered incredibly easy. In fact, if you read the cases that find a right to privacy, cases like Griswold that held that you cannot criminalize the purchasing of contraception, as well as other cases around that time, Roe versus Wade is actually a fairly obvious case, given a right to privacy that protects people from interference with their personal decisions. One thing that Alito does throughout this is, and he sort of summarizes Roe versus its reasoning, notes that 30 states still prohibited abortion at all stages at the time of Roe, that states have been liberalizing their views on that. And then the last big case was Planned Parenthood of Southeastern Pennsylvania versus Casey. And that's after Justices O'Connor, Kennedy, and Souter were appointed to the Supreme Court, all by Republican presidents. It was thought that they would actually ring the death knell for Roe versus Wade. But the 3 remaining justices signed a joint opinion saying that the Roe had some issues, but that stare decisis meant that they should uphold Roe's central holding, that a state may not constitutionally protect fetal life before viability, and overruled some decisions after that, and you came up with a test called undue burden, which most scholars believe was in fact Justice O'Connor's opinion. And by the way, my name's John. I have no relationship to Justice O'Connor. My last name is O'Connor. But be that as it may, the court upheld Roe versus Wade, at least as far as the rule goes, and there's a push to overturn this. And here's the big holding here. We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be, quote, deeply rooted in this nation's history and tradition, end quote, and, quote, implicit in the concept of ordered liberty. And that is generally a standard that has been used at different times to talk about what cases, when the court has recognized other rights, that the Bill of Rights or the Due Process Clause of the 14th Amendment applies. And Alito frames this as the right to abortion, right? The right to abortion does not fall within this category, and argues that such a right was entirely unknown in American law, and that when the 14th Amendment was adopted, the 3/4 of the states made abortion a crime at all stages of pregnancy, and so forth and so on. What's interesting about this is that Roe versus Wade, and to an extent Casey, were not based on a right to abortion. Rather, they were based on a right to privacy. That from the right of privacy, a right to choose for a woman to make a decision as to whether or not to have an abortion should be free from governmental interference. That's the ruling ultimately of Roe versus Wade and of Casey, that there should not be, Casey specifically moved it to, there should not be an undue burden on that right. And so in constitutional law, we refer to this as how you frame the question, what level of generality. At a larger source of generality, is there a right under the Constitution to be free from interference with the personal, private decisions made about one's own body by an adult? And that seems, most people I think would answer that question, yes. Is there a right to abortion contained in the language of the 14th Amendment? That seems to be what Alito's asking. And to be fair, the answer to that is probably no. And probably not a right under the that would have been recognized by the crafters and drafters of the 14th Amendment. As he says, Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage, but abortion is fundamentally different because it destroys what decisions call fetal life and what the law now describes before us as an unborn human being. Well, that's what Mississippi Code calls it. And so he states, Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. Which, as far as I'm aware, is not a basis that I've ever seen for upholding or overruling any decision of the Supreme Court. Doesn't have a role in stare decisis, but apparently, at least in this draft, Justice Alito seems to be suggesting it does. It's time to heed the Constitution and return the issue of abortion to the people's elected representatives, and then goes on from there. The Mississippi law itself, except any medical emergency or in the case of fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn being has been determined to be greater than 15 weeks. And so 3 months, just give or take, is the when the regulation of this would start. It goes on to talk about these things. The different bases for the rule. they talk about doing the critical question of whether the Constitution, properly understood, confers a right to obtain an abortion. This controlling opinion in Casey affirmed Roe's central hearing based solely on the doctrine of stare decisis. But as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. And essentially, it's interesting to note that this is an opinion that occurs in the first year that Justice Kennedy, who was one of the authors of the joint opinion, is no longer on the court. And so it is very derogatory, for lack of a better phrase, to the Casey plurality's opinion. And, he then goes on to criticize the crafting of Roe versus Wade, that the right to privacy has been found to spring from no fewer than 5 different constitutional provisions, the First, Fourth, Fifth, Ninth, and 14th Amendments. Roe does, in fact, say, look, the right to privacy can be found in any of these amendments, but there isn't a right to privacy, and so therefore, we by inference find a right to for a woman to make a choice. Bear in mind, this is a 98-page opinion, as is right now. It very well could be limited as it goes on. Alito calls it an unfocused analysis in Roe, that it's part of a liberty protected by the 14th Amendment's due process clause, and goes through this the regulation of medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless legislation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. And the court had previously stated in 1993, the goal of preventing abortion does not constitute invidiously discriminatory animus against women. I think fair minds can differ on that. I would argue that it does, but Alito says it doesn't. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny. Rather, they are governed by the same standard of review as other health and safety measures. We'll get to what that means later on. And then goes through the liberty interest. Now, the use of the quote over incorporation here, this is something that Justice Thomas has been pushing on, that he generally doesn't believe that there should be an incorporation of rights under the due process clause, and that in fact it should be a question of generally speaking, that he does not agree with the general incorporation doctrine. So this is a little bit alarming here. And then goes into this idea of whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's sense of ordered liberty. And goes through some issues like the Second Amendment, which the court found was incorporated against the states, and that liberty is a tricky term. As Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. And what the argument here is, of course, if you had a bingo here and were a constitutional law student or scholar, here's a reference to Lochner. Lochner is the case that gets trotted out consistently for a case that was incorrect. In its ruling, it found that under the Constitution there was a right to contract, and that it could not be interfered with by the government, and therefore the government could not set hours laws because that interfered with the right of workers to engage in deals with their bosses. And here, of course, Alito calls it freewheeling judicial policymaking. The clear answer is that the 14th Amendment does not protect the right to an abortion. Again, that Roe, and I think Blackmun, when he wrote Roe versus Wade, would say that's not the proper question. The proper question is there a right to privacy? and uh, uh, and so that's a different question. Justice Alito says there was no support in American law for a constitutional right to obtain an abortion. Zero, none. And again, he may be right, but that's not necessarily the proper question. And he goes through laws, English cases, which outlawed abortion, the reference to quickening, which was also referenced in Roe versus Wade. There was Hale and Blackstone explained in a way in which pre-quickening abortion could rise to the level of a homicide. Blackstone is one of the main foundations for Anglo-American jurisprudence. And that would the Alito talks about, again, Blackstone, which said that it was that abortion was a heinous misdemeanor, at least, and goes through the historical ground. But at least there was a distinction between, quote, pre and post quickening abortions, which is essentially a point at which the fetus has some sort of mobility or motility or some kind of evidence of life. And goes through different arguments here. Now, bear in mind, we're only a third of the way through this opinion. He says the inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, there was an unbroken tradition of prohibiting abortion on pain of criminal punishment from the earliest times. Again, looking back at the Roe versus Wade opinion, there are many different opinions by different justices there. And as I recall correctly, even all of them had different perspectives on why the law was unconstitutional. And it wasn't just a right to privacy. There was an Eighth Amendment argument that, punishing someone for something like that should be illegal, or that would be unconstitutional, and so forth and so on, based on the law as it was, as a finding of that there is a right to privacy under the Constitution. He argues against some opinions by both the Solicitor General and an amicus brief, and the different rights herein. And now, which is interesting, is that he's using the court's arguments about legislative intent here, and making the point that Roe and Casey did not question the good faith of abortion opponents, and we see no reason to discount the significance of the state laws in question based on these amicus suggestions about legislative motive. Which, if you've read other cases like Gonzalez and some of Scalia's dissents, I think it's fair to say he historically has questioned the motives of the pro-choice proponents. But be that as it may, here we get into, here we go, the right to privacy, finally. So cart before the horse, and now he's getting into the issue of privacy. The court did not claim that this broadly framed right is absolute, and no such claim will be plausible. While individuals are certainly free to think and to say what they wish about existence, meaning the universe and so forth, they're not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. Interesting. Quote, here's a good quote here. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be even more extensive. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys, quote, an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Again, that's eliding the question, I think. The question is not, is there a liberty interest? It is, at what point does the government's interest go up against someone's individual right to bodily autonomy, to right to privacy, the right to make those decisions without interference. And here are the cases that talk about other rights that have been recognized. Loving versus Virginia, Griswold, Eisenstadt, and so forth and so on. These are all important cases that you study in constitutional law that are different rights. The right to reside with relatives, the right to make decisions about the education of one's children, the right not to be sterilized, the right, not, in certain circumstances, not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures. And here's the right to autonomy. And he argues that those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. None of these rights has any claim to being deeply rooted in history. Interesting question. Which are these rights? He then argues that what distinguishes the abortion right from the rights recognized in the cases on which your own case you rely is something that both those decisions acknowledge. Abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions involve the critical moral question posed by abortion. They are therefore inopposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. So, at the very least, Alito is saying that all these other cases, Griswold among them, which has always been the main fear, that it would be targeted, because that's the right that finds an initial right to privacy, is not undermined in any way by this decision. We'll see how that goes on from subsequent cases, and if this opinion stays the same. What I find interesting about this is that if you read Roe versus Wade, it was an attempt to find a balance between those interests, between the interest of a government's right to an unborn life, such as it is, and a right for an individual to make decisions about what to do to their own body in a private, personal way. Those are the two competing interests. If there are those rights that are Justice Alito lists here, the right to obtain contraceptives, the right to marry, the right to make decisions about education, the right not to have involuntary surgery, forced administration of drugs, or other substantially similar procedures, what is a forced pregnancy? What is an obstacle to making a decision about, all these things? And so it is a balancing of two different rights. If these cases are correct, and Alito actually says they're correct, there is a countervailing right to the government's interest in the potentiality of life, or unborn life, as Mississippi tries to say here. So I don't think, at least this decision, Alito addresses that. It talks about how abortion is nothing new here. Now we're going into policy arguments, and argues that the court has that the arguments do not make constitutional arguments, but are policy arguments that must be sent to the states to make decisions. And now we get to the stare decisis argument here, because stare decisis is the idea that cases that have been in existence should stay good law because of the reliance on them. And to be fair, stare decisis is not inexorable. There are times when the court has overturned cases. Brown versus Board of Education overturned, and Plessy versus Ferguson. Other big cases that we salute and rely on overturned previous cases. And goes through sort of the general rules and laws about this. Here we go. Brown versus Board of Education, that's what they said, overturned Plessy versus Ferguson. West Coast Hotel overruled Atkins, which held that a law setting minimum wages for a woman violated the liberty protected by the Fifth Amendment's Due Process Clause. And finally, West Virginia Board of Ed versus Barnett overturned Gobitis, and that's a law that held that students could not be compelled to salute the flag in violation of their sincere beliefs. Alito's actually wrong on this one. I mean, he's correct that West Virginia Board of Education versus Burnett found that students could not be compelled to salute the flag in violation of their sincere beliefs after Minersville versus Gobitis had found that they could. And I always get these mixed up, but one of those decided it on the basis of religion and the free exercise clause in Minersville. And then the West Virginia Board of Ed versus Barnett decided it on the free speech clause. So technically, Gobitis was never overruled. There was a different argument presented in Barnett. So that paragraph, I'll be interested to see if it stays cited here. And here's a footnote of other cases in which different rules have been overturned. And the footnote goes on and on and on. And here he goes into why he thinks Roe was wrongly decided and compares it to Plessy versus Ferguson, which seems insulting, but let's see what he says here. Roe was on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors. The court usurped the power to address the Constitution, a question of profound moral and social importance. Those on the losing side, those who sought to advance the state interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. And the court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. And while that's true, it is true that when there are laws that are passed that are unconstitutional, you can't pass them again. That is basic constitutional law 101. Brown versus Board of Education silenced all the people who wanted segregation. It was still controversial. People, blocked school from desegregation, like put their bodies in the doorways. A governor did that. So that doesn't seem to have any, decision. Yes, wrongly removed an issue from the people in the democratic process. That is essentially what any constitutional ruling does. It says, look, there are, not any ruling, but a ruling that finds a law unconstitutional takes it away from the legislative process. That's the point of a Bill of Rights, which is often to protect the rights of the minority from the majority. The quality of the reasoning, it failed to ground its decision in text, history, or precedent. I don't think that's true. The trimester system has been criticized in many cases, but that's the weaknesses in Roe's reasoning are well known. Well, then we don't have to go into them, I guess. And the trimester system again has been critiqued as the court's own brainchild. Of course, this is what happens anytime the court comes up with a test for how to apply constitutional law. Frankly, one could argue that his deeply rooted in tradition test was also the court's own brainchild. Could be, it goes through the overall consensus of state laws in effect in 1868. It's striking, but the relying on the state of law from 1868 to discern the rights of the 14th Amendment has not been the lodestar of interpretation of the Due Process Clause. If it were, there would be no even approaching equal rights for women, and there would be no approaching equal rights for races other than African Americans, if this is correct. But I believe we've sort of all agreed that that is different. But argues, and here we go back to the right to personal privacy. the right to make and implement important personal decisions without governmental interference is the right we're talking about. This right here, the right to, and so forth. Pierce, Meyer, rights to marriage. I don't know that Griswold was really based on the right of marriage, since Eisenstadt versus Baird 7 years later said that you had the right to obtain contraceptives. None of the decisions involved what is distinctive about abortion, its effect, and what road turn potential life. So Alito seems to be saying that abortion is special and different, and therefore we're not overruling any other opinion. We're just saying that because there's a weighing of rights, it's up to the legislature. It's not up to the court. And that the court's flawed account of history. Well, that's only if you think that history is important, which Alito and a lot of the conservative justices do. He goes on to some of the logical reasoning. It's fair to say that if you look at Justice Blackmun's opinions post-Roe, they are much more tighter, so to speak, from a logic perspective. He did take the criticisms to heart. I think it's fair to say that it's not the most well-reasoned of opinions in terms of the logic applied. But a lot of opinions that come to the right conclusions are often that way. Brown versus Board of Education is an opinion that I heart and soul agree with. It's actually not a very well-written opinion, since it is based on not so much constitutional rights, but on sociological experiments that found that segregation caused a detrimental impact on African-American children. That's not exactly how you would want to base a constitutional law on some sociological study. But at the same time, I think it's completely correct to say that segregation is completely incompatible with the Constitution in any way, shape, or form. Loving versus Virginia is another case that 100% correct conclusion, but if you read it, try to decipher if it's based on equal protection or due process. It's not very clear as to its sort of the logic behind it. And just because an opinion is not very well written does not mean that it should be overturned, although Alito does seem to suggest that. And goes on about viability and how different cases have sort of overruled that or undermined that. Roe's weaknesses, White's complaints. Yes, well, White was also dissenting. And the United States asked the court to overrule Roe 5 times. That just points to it being a controversial case. Casey then didn't really defend the reasoning. That's probably true. Casey also deployed a novel version of the doctrine of stare decisis. Again, that's kind of insulting to the justices who wrote it. The undue burden test is problematic. How do you apply it? I mean, I think generally you would say, look at what courts have decided is an undue burden and then just don't do that anymore. I don't understand how that's not workable. I mean, if spousal consent notices are an undue burden, then any law that doesn't have that requires spousal consent for an abortion is unconstitutional. I don't really see where that comes from. So they, on that basis, they say that the undue burden test is unworkable somehow. And it goes on from there. And again, we just passed the halfway point of the decision. I'm just going to skim past some of this because he goes into why he finds that the undue burden test is unworkable, the effect on other areas of law, going through various dissents by people complaining about the problems of Roe versus Board of Education, the diluted the strict standards for facial constitutional challenges. Uh, I'll have to go back and check out the third party standing doctrine here. I don't know if I'd have to check out, see what they're thinking about that. Reliance interests. So it's a necessity in case of controlling opinion conceive that because getting abortion is generally an unplanned activity. But this idea that because pregnancies are done in 9 months, that there can't be a reliance interest is an extremely, let's say, problematic argument to make. Let's go with that. That is really an issue. Here he is poo-pooing the idea that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. But the court is ill-equipped to assess generalized assertions about the national psyche. Well, that may be true, but then the court should also be ill-equipped to decide whether or not a interest in potential life isn't just a generalized assertion about the national psyche. It would go. So I don't know the basis for that opinion here. Unable to show concrete reliance on wrong Casey themselves. I don't think that's. I think the way Alito's framing it is making it impossible to answer that question in the positive because pregnancy is short from legal terms. And so this idea that then he goes on to talk about how Casey looked at overturning Roe versus Wade would undermine the court's standing in public, but we can't allow decisions to be affected by any extraneous influences such as concern about the public's reaction to our work, which I find contradicts his opinion earlier on that this issue has caused great rifts in our nation's debates. Why mention how the controversy of this opinion if it's not supposed to be an issue? And so he sort of rejects that allegedly and notes that 26 states have asked us to overrule Roe and Casey. So, in your locality, if you disagree with this opinion, please vote accordingly in your state. So what is the standard? Now, this is the part that is most problematic, for lack of a better phrase. Rational basis review. Now, rational basis review is a standard that is extraordinarily differential. It is a standard that almost never is overcome. If you are challenging a law on rational basis grounds, you have to show, the plaintiff has to show that there is no rational reason for why the law could exist. And that includes reasons that the government doesn't even have to come up with, essentially, or didn't have in mind at the time. As long as there's some possible reasonable explanation for it, it will suffice. About the only thing that cannot form the basis for rational basis review is animus towards a particular group of people. And that is the one thing that the court has found is not a legitimate government interest. So the test for rational basis is reasonably related to a legitimate government interest. And those are very broad categories. And therefore, rational basis essentially means that any regulation of abortion is fine, and goes through a list of reasons. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. the legitimate interests include respect for and preservation of prenatal life at all stages of development would also mean that it's theoretically possible that a legislature could pass a law making it illegal for certain forms of birth control to happen. This is problematic on every single level. It's not. The conception going into this was that the court might undermine Roe versus Wade, the court might have a different standard for it, but that it probably wouldn't, would find that pre-viability abortions could not be regulated, or that, there was some sort of right in bodily autonomy that was still protected. This case throws that all out the window. And then here's a little bit more histrionics. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey abrogated that authority. We now overruled those decisions and returned that authority to the people and their elected representatives. And I will return to the caveats I said at the beginning. We don't know what the vote is on this. We don't know if there are any, if there is any possible concurrence that might limit the effect of this. This is a first draft. If the reporting is right that Chief Justice Roberts is voting more with liberals on this, all it could take is any one of the other justices, Kavanaugh, Coney Barrett, Gorsuch, potentially saying, I think this goes too far for whatever reason, and this could be mitigated. It's unclear. We'll know in June. It seems very bad. If this is, in fact, anything close to the final draft, it means that states have incredibly free reign to regulate abortion however they see fit, in whatever ways they see fit, because that is a very wide swath of quote-unquote legitimate reasons. And again, it could very well be that there is something different here. Could very well be that there is some kind of limitation, but we don't know. We won't know until we see the actual opinion. Is it bad that it was leaked? I think on balance, sure. This could be different. This could come out different. This is a first draft. If all of us were judged on first drafts, that would be terrible. But it's not as bad as what this decision might do to precedent. It's not as bad as what this might do to, more importantly, the rights of people nationwide to make decisions for themselves. So that's far worse, whatever, if this opinion holds up. So yeah, no, it shouldn't have been leaked. But the opinion itself is more problematic for all the reasons I've talked about now, and probably for other ones once I actually go through it more carefully and less off the cuff. If you've been listening or following along, thank you so much. If you're watching this later on, apologies for the stuttering and the fumfering, and thank you very much for paying attention and checking it out.